Hello, class, and welcome to Lecture Notes on the United States Constitution. I'm Mr. Barry, and on today's class, we will be discussing the principles that are in the Constitution, as well as what the document says about how our government works. To start talking about the Constitution, we need to look at the people who are behind the Constitution. And one of the main figures that we talk about when we discuss the Constitution is James Madison. James Madison was one of the drafters. In fact, before he even arrived at the Constitutional Convention, he had drafted a plan called the Virginia Plan. You may remember this from last notes, but it became the basic framework for the new Constitution. Madison studied many of the philosophies and the histories of the past to come up with his new plan for government. He was inspired by philosophers like Locke and Montesquieu, who we discussed in a previous lecture. His plan created a government of 3 branches with checks and balances to keep each branch from overpowering the other 2. After the final draft was created and sent out to the states for ratification, Madison, along with John Jay and Alexander Hamilton, defended the Constitution to the public in a series of essays called the Federalist Papers. Although James Madison is known as the father of the Constitution, he continuously insisted that it required many people to get the document created and in a form that everyone could agree on. The final draft of the Constitution was signed on September 17, 1787, though 3 of the delegates refused to sign it because it didn't include a Bill of Rights. Some, like Madison, didn't like the idea of a Bill of Rights because they feared that it would imply that the rights not specifically listed in the Constitution weren't protected. However, eventually those opposed to a Bill of Rights agreed to add one in order to ensure that the Constitution would be accepted. Delaware became the first state to ratify the Constitution on December 7, 1787, but 9 states would be required to put the Constitution into effect. On July 21, 1788, New Hampshire became that 9th state to ratify the Constitution. And then on May 29, 1790, Rhode Island became the last state to ratify the Constitution, though by that time it was already in effect. When studying the Constitution, there are 6 principles that we look at: limited government, republicanism, checks and balances, federalism, the separation of powers, and popular sovereignty. As we discussed in a previous lecture, the idea of a limited government goes all the way back to the Magna Carta, which limited the power of the king and gave some control to the nobles. The Constitution was written in a way that also limited the power of the government and protected the freedoms of Americans. The power is given to the government by the people, an idea that was influenced by the philosophy of John Locke, who we discussed in our previous lecture. It's up to the citizens to ensure that the government is held accountable and that personal freedoms are protected. It also means that no government official is above the law. Limited government was one of the main concerns of the framers when they created the Constitution. They did not want a strong central government, and so they were sure that they put in protections to make sure the government wouldn't get too tyrannical. The next principle is the idea of republicanism. Republicanism is the idea that power belongs to the people. In a republican form of government, the government gains its power from the consent of the governed. James Madison discussed this in Federalist No. 39. Madison said that republicanism is a government which derives all its powers directly or indirectly from the great body of the people and is administered by persons holding their offices during pleasure, for a limited period, or during good behavior. The next concept is checks and balances. Checks and balances are a way to help limit the power of the government by keeping one branch from overpowering the others. For example, while Congress, the legislative branch, may pass a law, the President, the executive branch, can veto that law, or the Supreme Court, the judicial branch, can determine that the law is unconstitutional. While this may make things slower or perhaps more inefficient, it also works to ensure that the government doesn't get too powerful and controlling. The fourth concept is the concept of federalism. Federalism is the sharing of power between a central government and a local or regional government. For example, in the United States, we have the federal government, which is located in Washington, D.C., but we also have state governments that share power with the federal government. So, for example, the federal government and the state governments both have the power to raise taxes, to build roads, or to create courts. This sharing of power is called federalism. The next concept is the concept of separation of powers. The separation of powers also work to limit the government from getting too strong. Under the separation of powers, each branch of the government has their own jobs and responsibilities. For example, the legislative branch's job is to make laws. The executive branch then administers those laws, and the judicial branch interprets the laws. While each of these branches has some sort of job related to laws, each of the jobs is different and separate. The separation of powers are another check and balance within the government. The final concept is popular sovereignty. The idea of popular sovereignty means that the people rule the nation. The Constitution itself begins by stating, "We the people." The government of the United States was created by the people. It can be changed by the people, and it derives its power from the people. Or as Jefferson said, the consent of the governed. Popular sovereignty is simply the power of the people to create or change their government when necessary. Now that we've looked at the principles behind the Constitution, we're going to look at the Constitution itself and what the Constitution sets up for the government. The Constitution itself is divided into 7 sections. Each one of these sections is called an article, and each article sets out a specific set of rules and guidelines for different branches of government. Before the articles, there's a section called the preamble. The preamble is the beginning of a document that explains what the purpose of that document is. In the preamble of the Constitution, it establishes the idea of popular sovereignty by explaining that it was we the people who formed the country and created the Constitution. The preamble also explains the goals of the Constitution. It says that the goal is to form a more perfect union or to create a better country, to establish justice, to ensure domestic tranquility, which means to ensure peace, to provide for the common defense of the country, to promote the general welfare of the people, and to secure the blessings of liberty for themselves and the people that come after them. Following the preamble is Article 1. Article 1 of the Constitution sets up the legislative branch of the government by establishing the House of Representatives and the Senate. The article describes who can serve in the houses, how the number of representatives are determined, when elections shall be held, and how laws are passed. It also includes the enumerated powers, which is a list of specific powers that the legislative branch has, such as to coin money, to collect taxes, to establish post offices and post roads, to promote the progress of science and the arts, to declare war, raise armies, and to make, quote, all laws which shall be necessary and proper for carrying out the powers of the Constitution. Article 2 establishes the executive branch and creates a president to oversee this branch. Under the Articles of Confederation, there was only a legislative branch, so this was a new part of the government. Article 2 sets up the Electoral College, describes how the president shall be elected, who is eligible, which is anyone who is a natural-born citizen over the age of 35. It also tells what powers the president will have and how a president can be removed from office through the process of impeachment. Article 2 also states that from time to time, the president shall give to Congress information on the state of the Union. Nowadays, that means a very large speech that's given to both houses of Congress every January. However, that's a newer tradition, and in previous years, it just involved writing a letter to Congress, letting them know what the state of the Union was. Article 3 sets up the judicial branch. Of the first 3 articles, this is the shortest of them. It sets up the Supreme Court and the ability of Congress to create lower courts as needed. It also outlines the idea of jurisdiction. Jurisdiction is the idea of who has the authority to hear a case. The other thing that Article 3 mentions is the idea of treason. It states that treason shall consist only in levying war against the United States or in adhering to their enemies, giving them aid and comfort. To be found guilty of treason, it requires 2 witnesses of the same act, and it also states that Congress has the power to declare the punishment. Article 4 of the Constitution explains the relationships of the states to the federal government and the relationship between the states. It includes requirements such as each state has to give citizens of other states the same rights as their own. As a reminder, under the Articles of Confederation, it was more a group of independent states loosely connected. But under the Constitution, it was saying we're all one big country, and citizens of Virginia should be treated the same way as citizens of New York. It also set up how a new state could be added to the country, and that these new states must have a republican form of government. Article 5 of the Constitution discusses how the Constitution can be amended or changed. There are two ways to amend the Constitution. The first is through Congress, and the second is through a constitutional convention. To make an amendment through Congress, an amendment needs to be proposed and then passed by 3/4 of the House and 3/4 of the Senate. That amendment will then go out to the states and must be approved by 2/3 of the states. The other way is to have a constitutional convention. In order for a constitutional convention to be called, 2/3 of the states must apply or call for a convention proposing amendments. All amendments to the Constitution have been done through the legislature or the congressional method. A convention has never been used. Article 6 of the Constitution includes the National Supremacy Clause, which states that the Constitution and national laws and treaties are the highest laws and can override state laws when they are in conflict. It also states that all senators and representatives and members of state legislatures, executive, and judicial officers are bound by an oath to support the Constitution, and that there is no religious test required for any public office. The final clause of the Constitution is Article 7, and it is the shortest. Article 7 outlines how the Constitution can be ratified, and as we discussed previously, it required 9 states to approve it before the Constitution could go into effect. One issue that wasn't originally discussed in the Constitution was the idea of individual rights. And this was one of the issues that kept people from supporting the Constitution because there was no protection for individual rights. As we mentioned before, some people like Madison felt that that wasn't necessary and that by listing specific rights, it would make people believe that rights that weren't included were not protected. However, since the ratification of the Constitution, numerous amendments have been passed that protect individual rights. For example, amendments have abolished slavery, they've defined citizenship, and they've provided equal protection under the law, as well as establishing voting rights for citizens. These rights protect people from being treated unfairly by the government. It means that we must receive due process before action is taken that deprives us of life, liberty, or property. And it ensures that we have equal protection regardless of our race, our gender, our religion, our political beliefs, or other protected statuses. Individual rights are protected under the first 10 amendments of the Constitution, and these amendments are known as the Bill of Rights. The Bill of Rights includes some of our most important freedoms, such as freedom of speech, freedom of the press, freedom of religion. It also gives us the right to protest against the government. It gives us the right to a trial by jury, and from cruel and unusual punishment. While there are many rights protected by the Constitution, there are also many duties and responsibilities that citizens have in the United States. First, a citizen is anyone who's born in the U.S., including in United States territories or on military bases. Non-citizens can become citizens through a process called naturalization. To become a naturalized citizen, you must be at least 18 years old, a legal resident of the United States who has lived here for at least 5 years, and show good moral character. Once you've done this, you can apply, pay a fee, get fingerprinted, be interviewed, take an English and civics test, and if you pass, you will take an oath of allegiance at a ceremony, after which you will become a citizen of the United States. As a citizen, there are things that you need to do. For example, you must obey the laws, you must pay taxes or sit on a jury, or defend the country when necessary. However, one of the most important duties is to understand how the country works and to participate in the process. This means being informed on current events, voting in elections, and participating in the political process by writing to representatives and having your voice heard. As Thomas Jefferson said, whenever the people are well informed, they can be trusted with their own government. Thank you for listening to Lecture Notes on the United States Constitution. If you're ever in Washington, D.C., you can visit and see a copy of the Constitution on display in the National Archives. For more information about the Constitution, visit the Library of Congress at www.loc.gov.